Okay, welcome to everybody. Good morning, good afternoon, or good night. I'm very pleased as a member of the RGT of AIPPI to welcome all of you to this new webinar. In every crisis, there is always some advantages, and in this COVID crisis, one advantage is, of course, small, but still, is that AIPPI was able to develop this new format, this webinar. And I would like to deeply thank the Standing Committee Copyright, and particularly Jan Nordman from Germany for organizing this new webinar on copyright and architecture. And before we begin, I would like just to inform you about some technical points very quickly. As attendee, you cannot speak, but of course you can ask some question. If you have any question, you can use the Q&A box and we will receive your question. I can't promise that we'll ask all the questions to the panelists, but of course, we'll do our best. And on the other end, if you have technical problems, do not hesitate to use the chat box. And Cynthia and Michel from the Zurich, and I thank them again deeply for organizing all these webinar and for preparing also the Congress. And they will try to help you if you have any technical problems. So now I leave the floor to Jan. Thanks again to all of you. And I'm sure that we have very interesting debate on this question on copyright and architecture.
Thank you so much, Guillaume, for these nice introductory words from Paris. Yeah, and that's indeed, as Guillaume said, one of the major accomplishments of the pandemic. You know, with all these disadvantages it had, it had one advantage, and that's that it is a lot easier now, and the threshold to access particular online seminars has gotten much lower. So it's great that I can say hello today to really the entire world. We must say we have around 200 people listening in today, and as the AIPPI Bureau, Michel Scherer and Cynthia Petruccello have confirmed to us before this event, we really have them from audience from all the continents in the world. That's really great, and that would, as I said, not be possible without the fast progress during the last month in online webinars. This is a copyright event, of course, and as you can see from the topic, we have chosen a topic that is maybe a little unusual in copyright, but as at least the copyright lawyers among you will know, copyright is really everywhere. Yeah, it is in books, it is in games, it is in movies, it is in music, and it is also in buildings. Reason enough to look at this with in a little more detail today. In the next 90 minutes, we will have Zurich time finishing at 2:30. Let me share the first slide with you, showing who will be. Let me see. Oh, sorry. Now what has happened, we had a rehearsal and everything went really fine, And now I'm not seeing my slide on the, just give me a minute. Just give it another try. Huh. Yeah. Is that my, sorry, Cynthia, is that my slide?
It's me sharing for you.
Yeah. Yeah, thank you so much. Because indeed, I think that is necessary, because somehow my slides have disappeared. As always, you know, something, sometimes it goes technically wrong. But that's fine. We can do with Cynthia sharing the slides. For me, as I said, copyright and architecture. So we are with recent cases from Europe we will present to you. We have put together a nice set of experts for you. First, I want to mention Melis Abacioglu Viskusenko from Turkey, and also Mine Guna Sunay from Turkey, who will present to us recent cases in copyright and architecture from Turkey. Giorgio Mondini from Italy will do the same from an Italian perspective afterwards, and then Guillaume, who you already seen, will do the same from a French case law perspective. Cynthia, next slide, please. You know, as I'm a German, I always have to start my talks with what the Germans call a Gliederung, which is a table of content. You know, the British always say about this German habit, the Germans start with a table of content and the English always start their presentations with a joke. And that's maybe the German joke, how to start their presentation. So what about today's table of content? We have two major topics today. Under the big headline, buildings may be copyright protected on the outside and on the inside. The first major topic is, what are the requirements for copyright protection of architecture outside and inside? And here we are looking at German case law. I will look at German case law in a minute, but then we will look at Turkish case law, Italian case law, and French case law. And the second big topic will be that an architect may have an interest to stop remodeling of a building due to moral rights. These cases are quite frequent, at least I can say that from a German perspective. There are a lot of cases in front of courts with architects trying to stop remodeling or even destruction of a building. So that will be our second big topic. Let me look with you into the German case law. And maybe, Cynthia, you can already do the next slide. We will look first, as I said, into the bigger topic of what are the requirements for copyright protection of exterior architectural works. I'm afraid I do not have too much case law on the interior, but I'm sure Giorgio, for example, will have that for us from an Italian perspective. Next slide, please. What does the German Copyright Act say about the requirement for copyright protection of buildings? The German Copyright Act, of course, because we are an EU member state, needs to comply with EU law regarding the requirements of copyright protection. And as you know, or if you are an EU lawyer, you know that there is nothing specific in EU law on copyright protection of buildings. there is not even a CJEU case on this, at least not that I would know. In the absence of specific EU law and specific EU case law regulating the question, I think we have to fall back in particular on the CJEU case law in the recent Cofemel case and in the recent Brompton bicycle case that I have on the slide here for you, if you were interested in these cases. These cases concern applied art. And you can also maybe interpret buildings as applied art because they also serve a use purpose. Yeah, they are not simply there to be nice. They do not serve a mere aesthetic reason, but yeah, I would also group them in the wider group of applied art. And here the German Copyright Act, in line, as I said, with EU law, says it needs to be an own intellectual creation in order to be copyright protected, the building. There needs to be a certain personality of the author reflected, i.e. by the architect, and this reflection of the personality of the author needs to be an expression of his free and creative choices. The degree of originality, I think, is rather low. Yeah, so mere originality is sufficient. You do not need a specific, higher standard of originality or so. Any building type can be copyright protected. Residential buildings, bridges, indoor swimming pools, yeah, public offices, you name it, everything can be copyright protected. Next slide. So what buildings do not meet the requirements? Of course, there must be some, yeah. I will show you examples in a minute. I think buildings are not copyright protected that are the result of mere routine labor that do not stand out from the mass of everyday buildings, yeah, and use only common architectural elements. Maybe let's look at some examples. Next slide, Cynthia. So I think this garage building is likely not copyright protected because it does not really stand out from mass design. It does not have any features that would reflect the personality of the architect of this garage. So result, Cynthia, if you press the button, please, no own intellectual creation. Second example would be a building called Elbphilharmonie, which is a famous new building in Hamburg, in the harbor of Hamburg, where we will have an AIPPI World Congress hopefully soon. So that's why I chose the picture. I think this is clearly an own intellectual creation and clearly protected. But of course, these are extreme examples, yeah? So what about the gray area in between? I've also brought you some examples here. Cynthia, next slide. Interesting case, noise protection wall of a German, on the German Autobahn, a German highway. The German Federal Supreme Court, BGH, thought already some years ago that this was copyright protected because it was sufficiently original, a lot of individual choices by the architect of this noise protection wall. Personally, I think that this decision is rather questionable, whether really noise protection walls should be copyright protected, but the decision is as is. Maybe also the German Federal Supreme Court had not really a choice because the lower instance courts, had already found that this was copyright protected on certain facts that could not be challenged by the Supreme Court of Germany later. Another example, Cynthia, maybe one further slide, is the German Reichstag, which is the current German parliament building in Berlin. the building is from the late 19th century, and the architect has been dead for more than 70 years, so no more protection for the building as such. But in the 1990s, the artist Christo and his wife wrapped the German Reichstag, and there was a German Federal Supreme Court decision on the question if this wrapping is copyright protected, and the German Federal Supreme Court found that indeed, since you may press the button, yes, thank you. This is an own intellectual creation by Christo, because the wrapping is sufficiently original. The wrapping could have been done in a different way. If you look at the details, indeed, there's plenty of room for individual choices to make. So that's what I can present you regarding, the whether of copyright protection of buildings. Let's move on, Cynthia, with remodeling of buildings. There have been a lot of cases in the past in Germany, and I want to show you some examples. Next slide, please. Of course, when you remodel buildings, there's always a conflict of interest between the author, i.e. the architect. He or she always wants to conserve the appearance of his or her work, especially wants to protect the work as such and her or his very personal relationship to the work. This is what is protected in Germany also by moral rights. Moral rights are not harmonized on the EU level yet, at least according to my opinion. So that's really up to national case law in Europe, if according to my understanding. This conflicts with the building owner's interest to use the property at his or her will, to modernize the building, to enlarge it, to change the purpose of use, you name it, just to do with his or her property what he or she wants. How does that play out in practice? Cynthia, thank you. And maybe one more button. Yes. So we have Article 14 of the German Copyright Act, which gives a right to the author to prohibit the distortion or any derogatory treatment of his work, which is capable of prejudicing his legitimate intellectual or personal interest in the work. So that's the moral right to integrity, to put it short, for the author. But that is, as is shown by the word legitimate, there is always a balancing of interests necessary between the interest of the author in keeping his work as is, and for architectural works, the property owner. So next slide, please, Cynthia. So how did the German courts rule on certain classes of cases? We have 3 cases that are brought with me, and another one. These are all German Federal Supreme Court cases involving an art installation in a museum on the lower left-hand side, on a miniature golf course, which was also copyright protected, in the middle, and on a light installation on the right-hand side. So, and all these cases were on destruction of the work. So destruction of the art installation in the museum, destruction of the mini golf course, and destruction of the light installation. Next slide, please. You can derive from these 3 cases 3 major principles. One, Cynthia? the first thing that I find very interesting, copyright-wise, is that the German Federal Supreme Court said destruction comes under the moral right. So the moral right applies, and you have to weigh the interests, yeah. Because there were also voices in German copyright law saying, well, destruction, the work goes away, so copyright is out of play. But that was not the result. Rather, the German Federal Supreme Court said, no, destruction is even the strongest form of, a very strong form to have an effect on the right of integrity, the moral right of integrity of an architect, for example. Next slide, please. As a second takeaway, the German Federal Supreme Court said, if we look at these cases, usually the building owner's interests will prevail, but only non-aesthetic interests count. Yeah. So what the building owner cannot say is, I don't like the building anymore. I think it's ugly and I want to destroy it. That's not an argument where the building owner would prevail. But if the building owner throws in, other reasons, non-aesthetic reasons, the building owner will usually prevail, such as security reasons. For example, the building is not secure anymore. I need to demolish it. I need to change the facade, for example, for security reasons. Other reasons, economic reasons. I need to change the building because I cannot rent it out anymore in this shape. Yeah, I had a case like that did not go to court, but had this result that the economic interest of the building owner prevailed. Environmental interest also in our current times will count heavily and underline the general rule that non-aesthetic interests of the building owner will usually prevail. Next slide, Cynthia. There's one exception that you have to bear in mind, and that's really important for the building owner. Before you destroy and demolish the building, you have to give the architect the chance to document the building. Or to take it away, the work. Yeah, but usually in for buildings, that's not possible. Yeah, so at least a chance to document. If you do not give the architect the chance, there's case law in Germany, also very recent case law, that provides for damage claims, in this case, to the architect. Yeah, in case they demolish nevertheless, but you didn't give the chance to the architect to document his or her work, damage claims, yeah, for moral right infringement. Let's look at one last example before I finish. Maybe you've been to Berlin already. That's also my hometown. There's been already some years ago, but I think still very interesting, a copyright case in the building of the new Berlin main station. On the left-hand side here on the slide, you see the plans of the architect. How he liked to do it. Yeah, you see the ceiling was round. The ceiling was a little cathedral-like. But then in the end, the Deutsche Bahn, which is the German railway corporation, they decided to do it differently. And they, as you see on the right-hand picture, they decided to do a metal ceiling, which is flat also, and it is not cathedral-like. So the architect sued to change the building, and the architect won, because the building owner, means Deutsche Bahn, did not sufficiently economically justify the changing. There was rumor that the change was only made because the CEO of Deutsche Bahn didn't like the cathedral-like ceiling and wanted to change it with something he liked more. And as I said, aesthetic reasons are reasons that don't count. Yeah, usually the building owner prevails, but not if you only give me aesthetic reasons and don't really give sufficient economic reasons. And that was the case here for the Berlin main station. So next time you come to Berlin, maybe you take a look into the lower floor and look at this, you know, nice example for a moral rights case on copyright of the architect. Yeah, that's all for me. Thank you, Cynthia, for helping me technically. I would now like to hand over the floor to Turkey and to two speakers we have. We have Mine Güner Sunay, and we also have Melis Abacioglu Viskusenko, both from Turkey. They will share their presentation. Melis is also the AIPPI Vice President. She's a partner of Abacioglu IP Services in Turkey. And Mine is the head of intellectual property practice of the ESIN Attorney Partnership, which is a member of Baker McKenzie Worldwide Group. Two learned experts of copyright law, and Mine and Melis, I'm very honored to have, we are very honored to have you on the panel, and you have the floor to tell us a little bit about Turkish case law on copyright in architecture.
Thank you very much, Jan. I will start as the first speaker. First of all, I would like to thank you for the introduction, and it's a great honor to be sharing this virtual floor with the all esteemed participants and speakers. And it's always a pleasure for me to have a shared or joint presentation or event with my friend Melis. It's not our first time. It's somehow happening, but we have co-chaired or shared a lot of events in the past, and it's always a pleasure to work with her as a friend and as a colleague. So I will share my screen now, and yeah, I think you can see it now, but just please confirm. Yes. We will be sharing slides with Melissa, and I will be touching the base on the regulations and the legal framework of architectural works, architectural copyrighted works, the definition and how they're protected. And Melis will go on with the case law and the recent precedents in Turkey. So my agenda will be covering the general overview and the scope and how the architectural work is copyrighted and protected. Well, a very general definition of a copyrighted work in Turkey is pretty similar to Germany, as we adopted the European law principles, and German law has a really great effect on Turkish law in that sense. So a copyrighted work, it is defined as an intellectual or artistic product bearing the characteristic of its author. So a copyrighted work should bear an originality. The threshold is not always very high. It depends on the type of the copyrighted work. And the other condition is a copyrighted work must be listed amongst the copyrightable works in the copyright law. The main headings, the topics are literary and scientific works, musical works, fine arts, and cinematographic works. Architectural copyrighted works is important in terms of this division, because architectural projects, the plans and sketches, are protected under literary and scientific works, which doesn't have to be, bear any aesthetic value, and those are basically technical papers. But the building itself can only receive protection if it bears an aesthetic value, and it will be a fine art copyright in that sense. Such aesthetic value criteria is also not always very high, but it is enough if it bears the characteristic of the author, and if it is somehow distinguished from the routine work or the, ordinary architectural work. So the definitions, I more or less defined those, but architectural work can be, it's a language issue here. It may be lost in translation, but if you say architectural work, it may not be always the building or the project. So in English, it may be a superior definition. But if we are talking about an architectural project, it is the technical paper, the literary and scientific works. The building, if it has an aesthetic value, it will receive copyright protection. Shapings in the interior of the buildings, it depends whether they are copyrighted or not, because sometimes it may be protected under design law, sometimes it may be subject to copyright law. My example is there might be an aquarium in a building, and if that aquarium is a separate, glass bowl or tank, it will be probably only receive protection under design law if the conditions are met. But if such aquarium is designed in a manner to separate two rooms from each other, if it is an inseparable, unseparable part of the building, then we may discuss that it can be a part of the copyrighted work and architectural work. Interior architectural projects, those are also, most probably falling under the scope of as a scientific and literary work if they meet the conditions. So some of the issues under this law, also, I took some notes from Jan's presentation that the issues and the regulations are pretty similar, but the main emerging issues in the case law are, first of all, stem from reproduction of an architectural project or continuing architectural, the structure with another architect's project. In this case of matters that the architectural project receives copyright protection itself, but the building owner or the project owner doesn't always have, the landowner doesn't always have to continue with the agreed architectural project, and he or she may decide to continue with another project. So as long as the secondary project, the later project is approved and the integrity of, the previous project is not used or is not altered, there might not be a copyright infringement. But even for personal use, a building cannot be built by duplicating an architectural project more than once. And an architectural project of an architect should not be altered or modified without the permission of the architect. So there might be some issues arising out of the conflicting interests of the architect and the building owner. The problem often arises if whether the building itself is a copyrighted work or not. Also, it is all around the discussion whether the building has an aesthetic value or not. If it bears the aesthetic value, if the court and the experts decides that the building itself receives architectural project, then only the necessary changes, technical changes, or the changes in terms of the safety or some renovation projects that might be done without the permission of the architect. Provided that such renovation or such technical changes does not harm the integrity or reputation of the architect. If the building itself doesn't receive any copyright protection, if the building itself is an ordinary building, if it's not a copyrighted building, then it is not, subject to discussion, because for the changes or the alterations or the renovations will not be subject to the architect's permission. So it is important to balance the interest of the architect and the building owner here. And it is important that the Turkish case law is still emerging. And until the mid-2000s, like in the last 20 years, it developed a lot. And until the mid-20s, regardless of whether the building has aesthetic value, the courts tend to rule that architectural projects or the building, any changes will require the architect's permission. But then the courts changed their opinion on that in a rightful way. Now it is widely discussed whether the distinction between the project and the building itself, and whether the building receives an architectural protection. So, and it only depends on the aesthetic value. As I said before, the aesthetic value threshold is not very high. It is enough that if it is distinguished from the ordinary routine work, in that case, the architect can oppose the changes that are made without his or her permission in the structure if it is somehow damaging the reputation or it is not necessary. So renovation of the finished buildings, and I mean, I will also touch base on the compulsory changes on the building. Architectural works are different from other copyrighted works as they must be functional apart from aesthetic concerns. People want to use a real estate they own for residence, business, or other needs. And sometimes the needs change. And sometimes a building is, structured and constructed as a residential building. Then in the, as some time passes, it can be changed. Reverted into a hospital or a school. The needs may change. So it is the question that even the change is compulsory, whether the change is compulsory, whether it is really needed, or whether even it is not compulsory, whether it can be done without the permission. So Article 16/2 of the copyright law says alteration and other changes cannot be made without permission of the author, and it is a non-transferable moral right. But a person who owns the financial rights to a copyrighted work and who owns the right to use of the financial rights can use the right to make alterations or changes as long as it does not tarnish, it does not damage, it makes a really huge damage to the author's moral rights or personality or reputation. There is no need to obtain permission from the architect for compulsory, beneficial, and necessary changes on the architectural work. In terms of compulsory changes, we can say that making the building earthquake resistant, this is a compulsory change, and whether the building is an architectural copyrighted building, there is no need to receive any permission from the architect for making the building earthquake resistant. Necessary and useful changes, again, is some simple repairings of the building, and also those doesn't require the architect's prior permission. So because we are sharing the slides and because we are sharing one slot, I will just, stop here and pass this on to Melis to share some examples from the case law, and I will stop sharing my screen.
Thank you very much, Mine. It's always my pleasure to work with you. Can you hear me, by the way? Okay. And I would like to thank you to all the remaining panelists as well. Jan, for just leading this on this, Guayam and Giorgio, and the technical support for Cinzia and Michelle, and for all the audience for participating on this beautiful Friday afternoon. So I would refer to emerging case law from the perspective of Turkey as a part of our presentation. Our first case is about a monument from Kars region in Turkey. The name of this monument is a monument of humanity, and it symbolizes peace. It was built as a goodwill step to maintain good relationships between Turkey and Armenia. So indeed, we can say that this monument bears a political message as well. The author of this monument is Mr. Mehmet Aksoy, who is a well-known sculptor both in Turkey and Germany. He's famous both locally and internationally. He has outdoor sculptures and monuments in these two countries. In 2006, as a result of a contract between the mayor of Kars and the sculptor, he has created the Monument of Humanity. Later on, the municipality assembly has decided to destroy this monument on the grounds that there are rifle emplacements made during the Second World War. And so therefore, the region has cultural asset characteristics. So they have decided that the monument is to be destroyed for purposes of public interest. Also, this decision has been widely discussed in national and international presses. Numerous artists and associations have spoken out to ensure that this monument will not be destroyed. And Mr. Aksoy has also filed an appeal requesting the annulment of destruction decision. However, at the end of a conflicting and a very long legal process, his request is rejected and this monument has been destroyed. After all, he has applied to Constitutional Court with the allege that his freedom of expression was violated due to the destruction of his artistic work named a Monument of Humanity. So the Constitutional Court's decision and its reasoning were as follows. First, the court has determined that the Monument of Humanity is a copyrighted artistic work whose author and the holder of the economic and moral rights belong to the sculptor, Mr. Aksoy, as per copyright law. And then the court underlined that artistic freedom of expression, which is a sub-branch of the freedom of expression, ensures that the works of the artist can be conducted freely without interference. Freedom of expression covers political, artistic, academic, or any expression of opinions and thoughts. By referring to the moral rights of the artistic work's owner, the court highlighted that the freedom of expression of individuals can be arbitrarily limited and therefore decided that the destruction of this monument constituted a violation of freedom of expression. Our second case refers to the Avant projects and the copyrighted work nature of Avant projects. So what is an Avant project? In other words, preliminary project. This is a proposal project in which the first thoughts about an architectural structure are illustrated with plans, sections, and views. While architectural projects is mentioned in copyright law, a definition is not provided. In our case, the plaintiff, who is an architect, has drawn a preliminary project, but this project is used by another architect for the preparation of an implementation project. Therefore, the plaintiff has filed a copyright infringement action and claimed moral and material compensation. The defendant, in return, has put forward that the preliminary project of the plaintiff is not approved by the Chamber of Architects, and therefore it is not a copyrighted work. The Court of Cassation ruled that apart from architectural works, all kinds of plans, projects, sketches, designs, models, and similar works are protected under copyright law, provided that they bear the characteristic of its author. An architectural project is protected as copyright work under copyright law, whether it bears aesthetic features or not. Avant projects are intellectual products within the scope of architectural projects. While it may not be possible to implement architectural projects unless approvals are received from the Chamber of Commerce or the municipality, these are only limited to administrative proceedings, and this is not related to the acquisition of the qualification of a copyrighted work. So it can still be a copyrighted work, even though no approval is obtained from administrative Chamber of Architects or municipality. Even if an Avant project is not validly approved, a work doesn't need to be registered in any registry and approved by any authority to enjoy copyright protection. So ultimately, the creation of the architectural work is sufficient to obtain copyright protection. And our third and ultimate decision is about the unauthorized alteration of the architectural work. Here, this case is about a parking lot which has been converted into a workplace without the consent of the architect. But in this case, the plaintiff is not the architect. The plaintiff has filed the court action against the architect with the claim that he has requested the consent of the architect for some compulsory changes. However, the architect here is refraining from giving his consent. Therefore, the plaintiff requested obtaining the consent through the court decision and also asked the question whether the consent of the architecture is needed in this case for this alteration. The first instance court accepted that the lawsuit on the grounds that the renovation project was compulsory, and therefore here the permission of the owner of the copyrighted work, the architecture's permission is not required. On the other hand, the Court of Cassation ruled that since this act includes making changes to the an approved architectural project, the first instance court must first determine whether such changes disrupts the integrity of the architectural project or not. And in addition to this, since it is a technical problem, it is necessary to obtain an expert report on whether the renovation disrupts the integrity of the copyrighted work. So some other Court of Cassation decisions regarding the limits of unauthorized alteration of architecture works. In 2017, the Court of Cassation indicated that minor alterations made by the defendant and the architect on the architectural projects prepared by the plaintiff do not affect the specificity of the project. Such alterations should be deemed compulsory due to the technique of adaptation, reproduction, performance, or publication. And this acceptance is compatible with the balance of rights and interests. So the plaintiff's objection to such minor alterations is against the principle of good faith. In another decision of Court of Cassation, it is indicated that architectural projects are accepted as copyrighted works within the scope of copyright law. The ownership is not in the architectural structure, but in the architectural project related to this structure. No alterations have been made to the architectural project, and therefore the plaintiff has no right to interfere with the alterations made in the architectural structure. Thank you for listening to us. This is all from Turkish perspective, and I would like to hand over the word to Jan for the next panelist.
Yeah, thank you so much, Mine and Melis. This is indeed very interesting. That although we have, of course, different copyright acts in Germany and Turkey, it seems to be, practice seems to be quite similar. That you, when it comes, for example, to changing the building, remodeling it, you also do a balancing of interests in Turkey, and that if I understood that correctly, every necessary repair is allowed. Yeah, so that sounds very similar to the German approach. One question we got from the chat, and I just I will address any questions after the talks. So please post any questions you have already in the Q&A part. Please not into the chat part, as Guillaume has said. Please into the Q&A section, yeah, of Zoom. One question that came up, and I think that's an interesting one, and I maybe just as a food for thought to think for all the panelists, can you do something in the contract with the architect to maybe waive the moral rights so that you don't get a problem? That's a question maybe for the discussion afterwards. I would now like to go from Melis and Mine from Turkey to Italy, to Giorgio Mondini, who is an attorney, IP attorney in particular, also with specific copyright expertise in Italy. Giorgio was the founding partner of a law firm that was called Mondini Rusconi until very recently, and they now have merged into the new firm Mondini Bonora Ginevra. Giorgio, please tell us something about latest Italian case law.
Thank you, Jan, for your introduction and for giving me the opportunity to present the Italian perspective on this very interesting topic, the copyright protection of works of architecture. I'm starting with a table of content like Germans, and briefly, I will say a few words at the beginning on the protection of architectural works under copyright law, and then we'll deal more specifically with the protection of interior design, interior architecture, especially in connection with the so-called concept stores. In other words, with the interior design aimed at characterizing commercial chains according to, in light of a recent case law in Italy known as the Kiko case. So I will start now with just highlighting the basic rules on protection of under copyright law of architectural works, even though the rules of Italian law are very similar to the German ones that were illustrated so well by Jan. So I'm feeling a little exempted from getting into much details about this part. Under Italian copyright law, architectural plans and works are protected, provided they have creative character. Of course, as mentioned by the previous panelists, works of architectures are works of applied art, combining aesthetic and utilitarian solutions. Creative character, however, is the only requirement for protection expressly provided by law for works of architecture, unlike, for instance, other forms of applied art, such as industrial design, for which Italian law provides, in addition to creativity, the requirement of artistic value. As mentioned before, the creativity requirement is interpreted as requiring a minimum degree of creativity. Traditionally, however, the old times, however, in spite of the express provision of our copyright law, courts tended to interpret creativity in a more restrictive way, in order to subjected architectural works to copyright only to the extent they had some merit, some aesthetic value, in addition to the general creative requirement. However, there's been an evolution in the court case law, with regard to this requirement of creativity. So, as I said before, while the old decisions stressed the necessity of some form of merit, in addition to the general creative character, right now, the creativity requirement is interpreted as I mean, in the sense that works must reflect the personality of the author as the result of the author's free and creative choices, in line with the notion of creativity adopted by the EU Court of Justice. I will just mention the most important cases that regard the definition of creativity, of creative character in connection with works of applied art. These have already been mentioned by Jan. However, they are starting from Painter regarding a photograph. Of course, we have to recall the Coffemel case regarding clothing, and finally Brompton bicycle case, in which the court found the possibility of copyright protection, even though this product is, I mean, is dictate. I mean, the form of this product, of this work, is clearly dictated mostly by utilitarian, by functional considerations. However, to the extent that there is some freedom, some space left from technical considerations, according to the Court of Justice, there could be a possibility of protection by copyright. Now, also the notion of architecture has changed over time. Traditionally, the notion of architecture was equivalent to the art and technique of designing and constructing buildings. Therefore, interior design projects could be protected as works of architecture only to the extent that the elements of which they are composed are inseparably incorporated into the building. However, the modern notion of architecture now has evolved and now includes any intellectual activity aimed at any modification or any creation, modification of spaces where human activity takes place. Therefore, now the notion includes not only buildings, both housing, public buildings, churches, schools, etc., urban development plans, gardens, prefabricated buildings, and interior design, as long as defined and as the creative composition of individual components and pieces of furniture, pictures, tables, and so on. Therefore, the position now of Italian case law is that copyright law applies to works of architecture and architectural solutions having a creative character, not aimed exclusively at solving utility problems or functional and technical needs. While interior design may also be protected under copyright without regard to the requirement of the incorporation of the furnishing elements into the building. Now we come to a particular situation, a particular problem of which is the interior design projects that characterize commercial chains, so-called concept store, which has come up with a recent case law. And in general, I would say that a concept store may be protected from different perspectives. In the US, for instance, the protection was found on the basis of unfair competition or trade dress. It's starting from the famous 2 pesos case against the Taco Cabana, while another form of protection of the layout and image of stores or outlets or restaurants is granted by the under the basis of trademark law as tridimensional trademark. And an example of this is the Apple Store, which is reproduced here, and which is a tridimensional trademark, according to a case also of the European Court of Justice. In this regard, it should be noted that even Kiko, the company which we'll talk later on, which is whose stores that was involved in the case law that I will shortly illustrate. Even the Kiko said applied for a trademark, tridimensional trademark, which however was rejected by the WIPO on the basis of based on the fact that according to the WIPO, the trademark lacked the necessary inherent or acquired distinctiveness. However, this is a possibility. Tridimensional trademark. Another form of protection of the concept store is given by, of course, the rules on industrial designs with regard to the components, the single components that may be protected either as registered designs and models or under the copyright applicable to works of design. And finally, the fourth form of protection is that given by copyright as works of architecture. And so the leading case in this matter is Kiko versus Wicon. Kiko is an Italian company operating in the production and marketing of cosmetics and perfumery products, which commissioned a few years ago an architect firm the creation of a new, innovative, and characterized layout for its stores. And on the basis of this layout, it opened several hundreds of stores throughout Europe. Another competitor, another chain called Wicon, opened a number of stores in the subsequent years, which presented similarities, substantial similarities with the Kiko concept, the Kiko and Yosaghini design project. The first attempt to obtain an interim relief against Wicon failed because both the Court of Milan and the Court of Rome thought that the layout, internal layout, formed of furniture components and fixtures, did not present the requirements for copyright protection or for the protection under unfair competition. The Tribunal of Milan, however, which was seized on the merits, came to a completely different conclusion and asserted that the layout of the Kiko stores was eligible for copyright protection, since it owned the creativity requirements with regard not to the single components of the furniture of the store, but the choice, the coordination and combination of such elements, such components, which was combination which was considered to be creative. You see here the stores, the two stores, Kiko on the right and Wicker on the left. As you can see, they're quite similar, at least from a general point of view, even though there are many differences. I mean, with regard to the components, you see here also other images of the two chains, of the two types of stores. The Court of Appeal of Milan confirmed the decision of first degree and made a distinction in its judgment between design, architectural design, or interior design and interior architecture. While interior design applied, according to the court, to the protection of the single components under design law or under the copyright applicable to works of design, interior architecture was the right definition of, with reference to a combination of components such as this one, characterized by a certain degree of creativity, being creative and original. Now, the in 2020, we had the decision of the Court of Cassation, which confirmed the findings of the Tribunal of the Court of Appeals, pronouncing stating the principle that an interior design project of unitary conception, adopting a defined and visually appreciable scheme which reveals a clear stylistic key of components organized and coordinated to make an environment functional and harmonious, manifesting the personal imprint, the personality of the author, can be protected as a work of architecture pursuant to Article 2.5 Italian Copyright Act, without regard to the requirement of inseparable incorporation of the furnishing elements to the building. The court also rejected the argument raised by the other party that the Kiko layout and design lacked the identification of a specific building service into which the work should be incorporated, and therefore should be treated as an assembly of furniture, not a work of architecture. According to the court, on the contrary, this combination of characterizing elements that were precisely indicated in decisions of the Tribunal of the Court of Appeals was to be treated as a work of architecture, not as an assembly of components that might be eligible to protection under design law. As you know, this would, designs under Italian law can be protected by copyright only if, in addition to having a creative character, have an artistic value. So, which is not the case with regard to works of architecture. So, the court said, or added, the Supreme Court added that to be protectable, the work of interior design must always be identifiable at the level of formal expression as a unitary work of the author due to a combination of a number of elements, and I mean, the color of the walls, the lighting effects, the repetition of decorative elements. I mean, while the combination and the unitary work, of course, must be original and creative, the single components could be common, ordinary, and even be used, be already lacking originality as used already in the same sector. In the case that the Kiko case, these elements which composed the unitary work according to the court, was to be considered as protectable under copyright, are indicated in this picture. They were found in the open space entrance, in the islands, installed inside the store, in certain graphic signs on the outside of the stores, in the discotheque effect lighting, and so on and so on. And they are indicated here, I mean, the open space entrance, the internal side displays, islands, and these are the elements which, even though common by themselves and not protectable by themselves individually, could compose a unitary work, which as such can be protected by copyright. Therefore, the final conclusion is that the design project developed by these architects, containing a minimum creative contribution suitable for deserving copyright protection, is to be protected by copyright as long as it is not the result of functional or banal choices. Banal choices by itself is original and creative. Now, I mentioned here two more recent decisions which applied the Kiko principle with regard to the inside the interior design work of a boat. One decision by the Court of Venice, which considered the inside project of a yacht was protectable under copyright, and a decision of the Court of Genoa, which on the contrary, in the specific case, said that the design lacked the necessary originality by itself, but applied the same principle. Now, just to come into the other issue, which is that of moral rights, I must mention that there is a specific provision of the law which represents an exception to the general rule on moral rights. And in general, authors are entitled to have the right, moral right to authorship, to integrity of the work, and may oppose any alteration or modification of the work which may be prejudicial to their honor and reputation. However, in the case of works of architecture, this provision states on the contrary that the author may not oppose modifications deemed necessary. And this is the word, of course, the crucial word, necessary. It has to be necessary in the course of construction. Further, the architect may not oppose other modifications which may be necessary even after the completion of the work. So, I mean, even after the building has been constructed, it can be remodeled if this modification is necessary. unnecessary for legal reasons or for environmental reasons or for other reasons. However, if the work is recognized by the competent state authority as having an important artistic character, the author must be entrusted with the study and execution of such modifications. And here you see that the merit requirement, the artistic value requirement, which was eliminated from the concept of creativity in general as a requirement for protection under copyright, comes back with regard to moral rights. In other words, if the building, but only if the building is recognized by the competent authority, which means by the Ministry of Culture, to be to have an important artistic character, then the author, the architect, has the right to study and execute such modification, but may not oppose
Giorgio,
such modification. I'm sorry, I'm finished.
So, yeah, Giorgio, sorry, we have to take a look at the clock a bit. So
yes, I'm finished. I'm finished, and therefore I thank you very much for your attention, and I'm leaving the floor. Thank you.
Yeah, thank you so much, Giorgio. That was really interesting, I think. You know, for example, the last slide covered Article 20 of the Italian Copyright Act, which seems to even have a statutory solution for the weighing of interests of the building owner and the architect. Also very similar to Turkey and Germany, you know, necessary changes, and then of course the lawyers come in to answer what is necessary. What I also find interesting was that it's no longer an artistic artistic merit that you have to show to get protection for buildings, but I think in line with CJU case law, which of course Italy also has to follow, it is now the personal imprint of the author. Yeah, so which is probably a little lower, but you know, practice will show. But interesting that Italy and Germany as EU member countries seem to be in line here, I think. But let's hear from, thank you, Giorgio, again, for this really interesting presentation. Let's hear from another EU member state, Guillaume, what France is doing in the area of copyright and architecture. Just a very quick presentation of Guillaume. Guillaume is in EIPBI. He's an assistant reporter general. I wanted to mention that because, of course, that involves a lot of work. And but Guillaume is also a practicing attorney in Paris, and he's a partner at the Slepper Henri Avocat law firm in Paris. Guillaume, you have the floor. Thank you.
Thank you again. I share my screen, and you see my screen? Huh? Okay, so I will try to make a quite short presentation for two reasons. The first one is if we can keep some time for the question is better, and the second reason is that in fact, as you will see, the situation is also quite similar in France. So first, regarding the requirements for protection, it's also quite similar. I mean that the only criteria to protect an architectural work is originality, or it means that it has also to reflect the personality of the author. So it's quite common, and as in Germany, for instance, I understood, we can consider that originality is in practice rarely denied, even if there is some decisions that are more severe with author now, but in general, it's not so difficult for an author and, for instance, for an architect to have his or her works protected by copyright. So I just give you some example of, just in order to see which criteria are used by the judges and that the decision for the Supreme Court. And the key word is in a lot of decision is combination. And the judge has to investigate if the various architectural details have given rise in their combination to an original composition, even if some details are known or common use in a region or are common heritage. Very often the judge, they focus on the combination of architectural shapes. I give you another recent example. It was an orangerie of the Argonne Castle, and the Court of Appeal of Douai in the north of France decided that once again, the various architectural details they characterize in their combination an original composition. One other decision relates to a mosque project, and we can see once again the words harmonious combination. And we have also some decision regarding the interior design, and we don't have a precise decision like in Italy that Giorgio, you explained us, but usually, of course, the interior of a building can be protected by copyright. But it's not always the case, and we have also a recent example. It's a Court of Appeal of Rennes, and they had to decide if the building itself was copyrightable, and also the interior of the building. And it was this building were only plans in 3D views. Huh? And regarding the building itself, the judge, they consider that the assembly is like the combination of several parallelopipedal structures, flat roofs, bay windows are not clearly distinguishable from those usually proposed by a similar project. So even if in principle it's not the criteria, but in fact to use this criteria, what we do as a lawyer and also the judges, we compare what did exist and what is the creation the work. And just one detail, but it's quite important. The judge, they explain that the plans that do not include, for instance, only example, indication relating to the choice of materials or colors of the building. Yeah? And it's exactly the same way for the inside of the building. I mean, in that case, it was not the design of the furniture, it was the design of the rooms. And the judge did also consider that the interior layout shown on the plans appear usual in the arrangement of the room, the surfaces, and the volumes. So it's exactly the same criteria, is it usual or not at the end. And it's not specific to architecture. Huh? It's quite usual for the French judge in practice to use these criteria. I mean, we have another example of works. It's the lightning. And for instance, we have a case where it has been recognized that the lightning of the Grand Arch in Paris is an original work. It's a composite work. Why? Because you have the first work, I mean the architectural work, and then you have a second work, the lightning of the building. So if you want to reproduce this building, you need to have the two authorizations. First, the architect, second, the author of the lightning. And that's the reason why it's usually considered regarding the Eiffel Tower. To reproduce the Eiffel Tower in the day, it's possible because the author it's more protected by copyright. But if you want to reproduce the Eiffel Tower in the night, when of course with the lightning, it's not possible because it's copyrightable and it's still protected, even if the company which exploit the Eiffel Tower consider that it has already been judged by courts. But I mean, if we read carefully the decision, it's not really the case. But we can consider that there is high chance that once a judge consider that it's not allowed to reproduce the Eiffel Tower with in the night. Now I move to the exception, and one exception is the freedom of panorama. We have this provision in the CP, it's the French IP code, and it's quite new because it has been introduced in our IP code in 2016, and it's now written that reproduction and representation of architectural works and sculptures permanently placed on the public highway made by individual natural persons excluded any commercial use. So that is an exception to the monopoly, to the right of the architecture author. It's quite new, and the major point is the construction of excluding any commercial use. And we don't have, I was not able to find a decision at this stage that did construe this expression, but I can give you an example. But it was before the introduction of this exception. But our Supreme Court already in 2005 did introduce a case law exception. But it was, please note that it was not relating to the building itself, but it was regarding the waterfall, the fountains there. And the Cour de Cassation did decide that the postcard, it was not exactly that image, but it was not able to find the real one. But they decided the postcard is intended to reproduce this protected road, and they only show the rock, I mean the waterfall, as an accessory element. So it was a new criteria, and it's no more in the law, because now we have the law of 2016. But it was this decision did highly influence the Parliament in order to introduce the current exception to the copyright of the architects. So now, regarding the moral rights, there are two major points. The first one is the right to paternity, which is quite usual for all works. But now we have a specific article, not in the IP code, but in the heritage code. And it's mandatory now to indicate the name of the architect on the building. Regarding now the right to respect of the work, one question was regarding the contractual possibility to manage the moral rights of the architect. Under French law, it's possible, but it's dangerous. Why? I mean, when we always advise to be very careful with contract on moral rights, because such contracts are not strong. And the idea is always that if the author, the architect, renounces very broadly, in general, to his moral rights or to the right to the respect of his work, I mean, there is a high chance or high risk that a judge considers that it's not possible. We have more chance that it could be considered as licit by a judge if the renouncement to the moral right is very precise. For instance, we can change the roof, or we have idea to extend some part of the building. In such case, we have more chance that it would be accepted by a judge. I just give you a few examples of case law regarding, in general, the respect of the work, and you will see that it's quite similar than in Germany, Turkey, or Italy. In such case, the judge did consider that the right of respect was not respected merely because the city did not demonstrate any technical imperative that would justify the modification of the building. So it's quite a similar example. Another one, this building has been destroyed, and the court did consider that it was possible, it was, legitimate and proportionate, and the judges used two different arguments. The first one is that the building is an utilitarian work and not a purely aesthetic work. And the second reason was that this building no longer ensured severe living condition for its inhabitants. So it was quite dangerous. Another example was this Velodrome Stadium in Marseille. And once again, the judge did accept the modification because it was in the view of the Euro 2016. And other quite old, because it was late 80s, beginning 90s, it was this restaurant on the top of a very famous theater in Paris. And at the end, the Court of Appeal of Paris did accept that this restaurant was built on the roof of the theater. But I mean, perhaps one reason, I don't know, but it could be that when the judge did render her decision, this restaurant was already built, so on the roof. I don't know if it was. I mean, of course, it's not creaturely, but I guess that it did influence the judge. So, in conclusion, regarding the moral rights, that's a specificity if we compare to other work, that the architect cannot impose an absolute respect for his or her work. Why? Because it's an utilitarian work. And like, for instance, in Germany, if the owner of the building would like to modify, to destroy, or so on the building, if he use aesthetic reasons, he has no chance. You have to use to argue non-aesthetic reasons, such as technical requirements, a legislation obligation to adapt the building to new needs, and so on. So that's the situation, quite comparable to the other country in Europe. Thank you.
Yeah, thank you so much, Guillaume. This is really interesting, I think, on the question of moral rights of the architect and remodeling of buildings, or adding parts, as you've seen in your restaurant example, Champs-Élysées, that we are not talking about harmonized EU law, because moral rights, as I see it, are not harmonized in the EU. But still, we come to the result that Italy, France, Germany treat these cases at least with very similar concepts, and even Turkey does so. So interesting how these concepts have developed. I don't know if the judges in the different countries have talked to each other, maybe, probably not, but probably just, it's just a reasonable concept that can really handle the cases. And also, interesting to see that also originality has a pretty low standard in France. I think you mentioned, Guillaume, that rarely ever denied originality. So that's also in line with Giorgio has said, and I think also pretty similar to Turkey, that that the standard is not too high, and at least does not require any artistic input. Yeah, before let us now maybe, I mean, we are a little overdue, but I mean, if people are still interested, maybe we can hang on for some more minutes. What I would be interested, maybe as a question, because these questions came up also in the questions and answers of the audience, would be the contractual waiver of moral rights of architects, if that's possible. Guillaume, you mentioned that already. It's kind of difficult. You said you have to be very precise, very, you know, very specific what the architect should allow. So general waivers are not allowed. I can say from a German perspective, exactly the same in Germany. Yeah, again here. You have to be very precise. You have to say, for example, in your restaurant example, the contract would have to say, I, as the building owner, are allowed to add a restaurant on top of the roof. And there you go. It's difficult to think ahead, you know, what you would want to do as the owner with the building. But maybe Giorgio and Melis and Mine, how about contractual waivers of moral rights by architects in your jurisdictions? Any insights?
Well, as you know, in principle, moral rights may not be waived by contract. However, in this particular case, with connection with works of architecture, I haven't seen any case law on this point. But I would say that since there is an exception, which I tried to illustrate before, to the moral right with regard to the right to oppose alteration or modifications in favor of the building owner, because provided there is a necessity for these modification, alteration, to the extent that these contractual clauses refer to specific cases of necessity or technical reasons that may come up after the building is in place, I would say that these could be acceptable and could be legally enforceable, in my opinion. I don't think there is any jurisprudence, any case law.
Thanks, Giorgio. Yeah, so pretty similar to France and Germany as well. How about Turkey?
Yeah, pretty similar to, I mean, Melis raised hands, but I've already typed in the Q&A form online, as the moral rights are not contractually not waivable. Then I will turn to Melis if she has any other additional notes.
I agree with Giorgio and Mine. I also think that this is enforceable in Turkey because you can always foresee a penal clause, and then I think it turns to a contractual obligation. But this does not mean that this is in return for the waiver of your moral rights. But in case your moral rights are infringed, you can put in the contract a penal clause about this, and I think that this is enforceable.
Okay, interesting. Yeah, so you should, I think, at least if you accompany for a large building owner the construction of a building, you should maybe think about introducing some kind of language into the contract, although, you know, it may be risky in all of our jurisdictions to do that, but still it's maybe better than nothing. Yeah, that's how I think, if I represent the interests of building owners. Maybe another question that was brought up in the Q&A is, how about the panorama exception? You mentioned it, and Guillaume. So if I just a question to you, and then maybe the others can answer it as well. How about the Tour Eiffel, the Eiffel Tower? if you do a postcard and sell it, the Eiffel Tower at night, yeah, which is copyright protected, as we've learned from you, because the lighting is, the lighting concept is copyright protected. So such a postcard in France would be not allowed under the panorama exception because it's commercial use. Is that correct?
In fact, I don't know, because we don't have construction by the courts of that exception. But I fear that it's not possible, but for another reason is that the lighting of the Eiffel Tower is a work, but it's not an architectural work. It's another work. It's like a lighting work. And the exception relates only to architectural work and sculpture. And when the judge has to construe an exception, I mean, in French law and in many legislation, it's only in a restrictive way. So I fear that in such case, there is a risk. Of course, I'm not sure, but there is a risk that a judge considers that the lighting of a building, it's not in the scope of that exception.
Ah, okay. And maybe to add another question, if you do the football stadium of Marseille, which you showed as well, which is copyright protected, if you do a postcard of this stadium, which is clearly an architectural work, that would commercial postcards would not be allowed in France. Only private photos.
Yes, in my view, in my interpretation of this exception, I agree with you. If you sell a postcard, is a commercial use. Okay. But probably if we have to combine also with the previous jurisprudence of the Cour de Cassation, if for instance, you make a photo of a match of a football in the stadium, of course, you can see a part of the stadium. And in such case, I think that the exception could apply. And we could use first the exception, and second, the fact that it's only accessory. And to the photo, to the postcard that we exploit. But I mean, with exception, we know that it's always, we are always borderline. With exception.
Yeah, thank you, Guillaume. That's really interesting. Giorgio, what do you think?
We do not have freedom of panorama, first of all. So we had cases
you don't have any?
No. I mean, if you make a picture and you reproduce a building in the center of Milan or Rome, you may be exposed to a possible lawsuit for violation of copyright in the building. But we have another peculiarity that not under copyright law, but according to the law on fine arts and historic and cultural heritage, that even the commercial reproduction for commercial purposes of the Colosseum or of the Pantheon or of Michelangelo's David and so on, maybe is subject to the authorization, to the permission of the state or of the city. And there were cases in which such reproduction was punished by penalties. It came up on the press as a very few cases. But I mean, this is not in copyright law. Is a specific legislation, the protection of Italian cultural heritage. So this means that it's anywhere you go in Italy, because we have so many buildings, so many historical, you may run into the risk of violating either copyright law or this specific legislation. So you must be very careful.
Okay, thank you. What about the panorama exception in Turkey?
Well, there is not a specific rule in the law that is defined as panorama exception, but it is it falls in the scope of an exception taking pictures of a monument or an architectural building that is erected in a street or in a in a public area. So it doesn't constitute infringement if someone takes a picture and so on. But of course, the picture itself or the further work may constitute copyright. So it's another issue, but it is under the freedom of copying, basically. But the law doesn't say panorama exception for that.
Okay. And is it, Mine, is it just private copying or also commercial copying that is allowed under this exception in Turkey?
Well, it's for personal use only.
Oh, okay.
But it may depend on the monument, because if it is like an historical monument, there might be some regulatory requirements to get permissions.
Okay.
But still, you can take pictures or make card postals or commercialize it, so it's free if it is in a publicly available area that people passes by, and if it is not a monument that you can buy a ticket to see, if it is on the street, if it is free, for everyone.
Okay. So that's very interesting. Thank you, Mine. That's very similar to the German approach, because Germany has a panorama exception which covers private and commercial use. So also the postcard guys, for example, that sell the postcards. But you have to make the picture or the reproduction of the building from a public place, public accessible place. So public street, like you said in Turkey, not if you are within another building or so, or do the picture from the roof of another building, that would not be covered by the panorama exception. So interesting. All the countries have different approaches to the panorama exception. Obviously, we are not really in harmonization here, not in the EU and including Turkey, of course, here. That's also very interesting, but that's because the EU Directive 2001/29 makes it only an option for the member states, EU member states, to have a panorama exception or not. That's why, for example, Italy does just not have one. And that is even fine in EU law. So looking at the clock, I think we could probably carry on for some more time. Maybe I can tell the last joke of today. When I spoke to when I gave a talk last in England, I also asked the moderator, so how long can I talk? And he said, well, Jan, you can talk as long as you want to, but we'll all go for lunch at 2. I think I just want to finish with that. Probably you are all exhausted now, and maybe you have to go to lunch even still, or maybe have dinner or breakfast wherever you are in the world. Thank you for listening in. Thank you again for the excellent presentations by Melis and Mine, by Giorgio and Guillaume, and interesting panel. I think we have to do this again, maybe with another copyright topic. There are so many different copyright topics, so many different areas where copyright is relevant. So I think we can continue this as a series even, or think about it. I would like to finish with a little advertisement for the AIPPI World Congress Online 2021, which will take place very soon from October 15 to October 22 this year. Registration is still open. AIPPI would be very happy if you could register and join. This year still online, next year hopefully again in presence. Thanks again to everybody for listening in, to the panelists, and goodbye for today. Bye-bye.
Thank you.